Our next case this morning is Selliman versus Colton. This is a 15-minute mini oral argument on the application. Welcome, counsel. You may reserve some of your time if we do not use it, which has not been successful yet this morning. But we ask that you keep track of it, and you have 2 minutes of a free fire zone if you wish.
Thank you. Good morning, Your Honors. Rachel Ratton on behalf of the plaintiff appellant. I'm going to try my best to reserve some time for rebuttal, but based on Justice Welch's comment earlier that there may be some questions for me, I'm not super confident that that's going to happen.
That's fair.
This court's order directing argument on the application asked the parties to address 3 points. I'd like to start with the third point first because I think that answer provides the narrowest path to resolution of the issues raised in my appeal without going too far beyond my case. Point 3 questions whether the Court of Appeals properly applied the abuse of discretion standard when it reversed the trial court's denial of defendant's motion to strike plaintiff's expert. Plaintiff submits it did not. In fact, the Court of Appeals really gave no deference to the trial court. Defendants originally asked the Court of Appeals to find an abuse of discretion in a decision the trial court had yet to actually make, which was whether or not plaintiff's expert was qualified under MCL 600-2169. The trial court had concluded that there were multiple questions with multiple answers during the deposition of plaintiff's expert, and that based on these seemingly contradictory statements, it could not determine at that time whether plaintiff's expert was qualified or not. Plaintiff argued below that this ruling was well within the range of principled outcomes when measured against recent rulings of the Court of Appeals, affirming the wide discretion afforded to trial courts in evaluating a proposed expert's deposition testimony and giving deference where the trial court's interpretation appeared to directly contradict the actual testimony. And some of those cases were actually mentioned by Ms. Howard in the previous argument, such as Turkish. The abuse of discretion standard recognizes that there may be no single correct outcome in certain situations, and I think certainly recognizes the trial court's discretion to refrain from making such a ruling if it does not feel it has enough information in the record at a particular time to make the determination. Remember that this was a denial of a motion to strike without prejudice, so the defendants were free to challenge plaintiff's expert's qualifications again at a later date by way of a renewed motion under this very statute or pursuant to MRE 702 or any other number of mechanisms. The trial court's ruling reflected a reasonable and principled outcome under the circumstances, and in finding to the contrary, the Court of Appeals clearly erred. Turning to the second issue, and this is where the road to resolution begins to widen, the Court of Appeals also failed to properly apply the requirements of 2169. There is no dispute Dr. Armstrong, plaintiff's expert, satisfies subsection A, which requires board certifications to match. Defendant, plaintiff's expert, and defendant's expert are mirror images of one another. They hold exactly the same board certifications. And in this case, we're talking about 2 separate boards from 2 separate entities, not one board with a specialty and a subspecialty, or even 2 boards within the ABMS. To borrow Ms. Howard's example, if you put these men in a Venn diagram, it's a perfect circle. They overlap. They are the same. There are certainly cases, like the one you just heard, where a dispute arises over whether it's a specialty or a subspecialty that is more relevant, but that is not this case. So having matched the board certifications under subsection A, we move to subsection B of the statute, which is the professional practice requirement. And where the Court of Appeals erred here is that the panel took as an established fact that facial plastic reconstructive surgery was the one most relevant specialty. The Court of Appeals panel said the trial court had already made that determination. But plaintiff maintains the trial court had not explicitly ruled facial plastic and reconstructive surgery was the one most relevant specialty. To the extent it implicitly did so, it did so from the bench when denying defendant's motion to strike. And as is clear from the transcript in the record, this determination, if it can be called that, was based on defendant doctor's self-serving affidavit, which was attached to his principal, not to his principal motion, but to the reply, which plaintiff could not respond to. Excluding...
So slow down. You're going a little fast for me. I'm sorry.
I talk fast.
So is the best resolution in this case to simply send it back to the trial court and say, what did you mean?
No. I don't think
so.
that is the best
No,
resolution.
I didn't think that's where you're going. Okay.
Because the reason I don't think that's the best resolution is because the main problem here is this one most relevant specialty requirement that Woodard, this test that Woodard gave us, that is not in the statute. And if you set Dr. Colton's affidavit to the side, the defendant doctors here, what was in the record at the time the judge made his ruling on the motion to strike was the deposition testimony of plaintiff's expert and the defendant, plaintiff's affidavit of merit, which said the standard of care is both otolaryngology and facial plastic reconstructive surgery, and defendant's expert's affidavit of meritorious defense, which employs nearly identical language on the standard of care and the clinical practice requirements. That's what was before the judge when he made this determination. And because Dr. Colton was deposed before Dr. Armstrong, he wasn't explicitly asked about the division of his practice for two reasons. There was no dispute at that time over the relevant specialty or the qualifications because the retained experts in this case had already agreed, based on their affidavits that were in the record, that it was both. It was otolaryngology and facial plastic reconstructive surgery. To send this case back to the trial court, you're putting a judge in the same position of deciding, is it otolaryngology, is it facial plastic reconstructive surgery, which kind of leads to the third point, which is the most important point here. The one most relevant specialty test is unworkable, and that's why Woodard needs to be revisited.
Okay. You essentially argue that the one most relevant specialty test is just inapplicable, logically inapplicable, and can't, because there are two specialties in this case, and they overlap, and one shouldn't prevail over the other, correct?
Correct.
But it seems to me your position then would revert us back to the statute that existed before the current statute, the 1986 statute, which essentially said that the proposed expert only needs to specialize in the same specialty or a related relevant area of medicine. Why should this concern that I have, why should I not be concerned about this?
Sure. So I've spent a lot of time reading the statute because amici and defendants claim that my issue isn't Woodard, it's the statute. So drilling down on the actual language of the 1993 statute, what is in effect right now? It discusses setting the appropriate standard of practice or care. So not even the relevant standard of care, the appropriate standard of practice or care. There can be more than one, plaintiff argues, appropriate standard of care. There can sometimes be no one relevant specialty. In this case specifically, the standard of care for performance of a rhinoplasty procedure is the same. It doesn't matter if you're doing it for cosmetic reasons, it doesn't matter if you're doing it for functional reasons, the standard of care is the same. So it still works under this version of the statute, and I thought of perhaps what a good test would be, because I thought your honors might ask, which I think if you look at the 1993 statute, you start with A, start with 2169-1A, which discusses matching board certifications. And I think you need the board certifications to match. I think you need to look at what these doctors picked up certification-wise. You've got to deal with the subspecialty, specialty, are those the same thing in terms of certification issue? But in this case, that doesn't exist. These men hold these same board certifications from separate boards. They satisfy subsection 1. Contrary to Mr. Cook's position, I think you still have to look at subsection 2, even if there's only one technical board certification on the books, because the statute says you need to look at A and B. So you got to turn now to B. And if you look at that, which is the clinical practice requirement, the statute said, or the professional practice requirement, excuse me, the statute discusses that the expert needs to have devoted a majority of his or her professional time to either or both the active clinical practice or the instruction of students. That language, either or both, to me, means there can be more than one. If you can be both spending a majority of your time in a clinical practice and in the instruction, doing two different things, why can you not also spend a majority of your time practicing two separate specialties especially when the specialty permits you to do the procedure and the standard of care is the same for the procedure regardless of the specialty under which you're performing the procedure. A facial plastic reconstructive surgeon doesn't get to perform a rhinoplasty procedure in a way that an otolaryngologist does not. He can't come in as a facial plastic reconstructive surgeon and say, you want your nose to be really, really thin, so I'm gonna take out all of the bone I want to achieve the look that you want, and then it have result in some functional deformity. Just like an otolaryngologist couldn't do that. You have to perform the procedure in the same way. It doesn't matter what hat you're wearing when you do it. The standard is the standard. It's what a reasonably prudent physician would do under the same or similar circumstances. And when you are identically board certified, you are identically trained, your practices are the same. These two men even both own their own practices. These are the same man. It just depends what they want to call themselves on that day and how they describe their own practice. I do med mal work, I do provider work. It just depends how I want to describe myself that day. I'm still an attorney. You are what you are. These men are facial plastic reconstructive surgeons and they're otolaryngologists. And that's why the one most relevant specialty test of Woodard needs to be revisited. I like Mr. Cook's description of it as the nuclear option. I am here for the nuclear option. Woodard needs to be addressed. It needs to be torn apart, rebuilt. Some things I think are good in Woodard. It's not perfect, as evidenced by the fact that not even the justices couldn't even agree on what the majority opinion was. How are practitioners in trial courts supposed to figure this out?
So the easy thing to do is to drop the bomb.
Agreed.
So now tell me what the rule should be.
Sure. So I think the rule should be you look at the board certifications. So in my case, Dr. Colton, we'll start with the
Don't tell
defendant.
us about your case. Give us the general rule that's going
Match
to
the
apply
boards.
from this point forward.
Sure. Start at the top, match the boards. What are you board certified in? I think the easiest way to do that is to look at the ABMS and the osteopathic counterpart, which has, it's kind of like the national standard of boards. There are separate boards, which is what the facial plastic reconstructive surgery board in this case is. They're these separate non-national boards. I think it's easiest to stick with ABMS certified boards, these nationally recognized boards. But Woodard does discuss why they don't think that's necessarily fair, and I don't fully disagree with that. I just think it's easier from a practitioner point. If you say ABMS is the universe of boards, you look at what the defendant has from within that catalog of board certifications. You need an expert whose board certification matches that defendant's. That takes you through subsection A of the statute. Then we get into the clinical practice requirement. That's where the one most relevant specialty test comes in, and that's what the problem is. The one most relevant specialty test needs to go. And you need to
Telling me what needs to go isn't giving me the new rule.
The new rule should be, what is the procedure that is being practiced? And what specialty performs that procedure? And the answer may be more than one. And if the proposed expert performs that procedure, even if it's under a different specialty, he is qualified. That's it.
You got a minute and 52 seconds. You can
I
keep
will
going, or you
try
can try
to
to say.
reserve. I'll try to reserve that.
Okay.
All right.
Good morning. May it please the court, Jeff Garish on behalf of Dr. Colton. The Court of Appeals in this case correctly applied the one most relevant specialty rule from Woodard. Woodard correctly interpreted the statute. The Court of Appeals in this case correctly held that the trial court abused its discretion because the court failed to adhere to the mandates of the statute as correctly interpreted by Woodard, plain and simple. The plaintiff casts his argument in this case as a criticism of Woodard's adoption of the one most relevant specialty test. That's not at all what it is. It is nothing less than a criticism of the statute, of 2169B1. That's what it is. As demonstrated by the fact that she's never been able to explain how Woodard was wrong, how a different test should have been applied. There's a reason why all 7 justices of this court agreed with the one most relevant specialty test. What divided the concurring opinions was the one concurring opinion would have made all the specialties match, not just the one most relevant specialty. I know she doesn't want that, but all 7 justices agreed that the one most relevant specialty test has to apply because that's the only way to interpret the statute. And her argument is nothing more than an attack on the statute. Justice Zara, your question was exactly right. What the plaintiff would like this court to do is say that the legislature was wrong in adopting the 1993 amendments, or that the legislature was wrong in not also adopting a logically inapplicable exception. That's the other way you could say it. She's saying the legislature should have put in a provision that says, you know what, when this majority in the same specialty requirement isn't logically applicable, you don't have to apply it. But the legislature didn't put in a provision in that to that effect.
But counsel, do you think, was the legislature really worried about a case like this where the specialties absolutely match?
Oh, I think they were worried about it. And in fact, I was going to talk about this later because I wanted to say a little bit more about the statute. But the whole argument that the test is logically inapplicable to this case is simply wrong. It's wrong, and it misunderstands the case. In fact, I want to quote from the dissenting opinion from the order that granted our app for leave. That one judge would have denied the app and said, I want to quote her, she said, the standard of care for performing a rhinoplasty is the same regardless of whether the rhinoplasty is performed for cosmetic or medical reasons. Accordingly, the one most relevant specialty formulation is logically inapplicable to this case. My sister counsel said the same thing. The standard of care for performing a rhinoplasty is the same. This case does not involve the defective performance of one rhinoplasty. That's not even close to what this case involves. This plaintiff had 12 rhinoplasties. He had 3 with the plastic surgeon before he even got to Dr. Colton. This doctor performed 3 plastic surgeries. He was dissatisfied with all 3. The doctor finally said, I give up. I can't make you look how you appear. So then he went to Dr. Colton. Dr. Colton performed another 6. Each time the plaintiff was dissatisfied with his appearance. And then Dr. Colton performed a 7th that the plaintiff says shouldn't even have been done. And I think this is worth pointing out. It's on page 212A of the appendix. Page 4 of their response to our motion to strike, they say Dr. Colton inexplicably performed a 7th rhinoplasty. And they also say that he was wrong to have certain steroid injections on 2 different occasions, 6 on one occasion and 7 on another occasion, for the sole purpose of improving his appearance. That's what this case is. So the notion that there's no logical basis for the legislature to say that the standard of care in a case like this requires that the specialist spend the majority of his time doing facial, plastic, and reconstructive surgery as opposed to ENT, the notion that there's no logical basis for that is wrong. There's a very logical basis for it. I mean, an ENT, I assume, has no idea whether it's a good idea or not to perform the 7th rhinoplasty surgery after the first 6 were unsuccessful. I mean, I think it's reasonable to assume that as between ENT and facial cosmetic surgery, there's a different cost-benefit analysis that goes into it. I mean,
But they both know how to do the surgery.
That's true.
Right, because
That's
they have
correct.
the same certifications and have both spent time doing both.
Correct, but the standard of care applicable in this case involves all these other activities, whether to do these steroid injections, how many times to do it, whether to do the 7th surgery. The cost-benefit analysis that a cosmetic plastic surgeon faces, I respectfully submit, is very different from the cost-benefit analysis that an ENT undertakes in deciding whether and how to perform one rhinoplasty.
What about, I mean, this is obviously lots of hard questions here, I realize, with what Woodard has created. What about if nobody spends more than 50% of their time on a procedure? Like, it's a rare procedure. Somebody is one of the top, there's 3 top experts in the world, and none of them spend more than 20% of their time on that. Is nobody qualified?
Obviously, that's a tough hypothetical. I think in that case, if there's, say 4 different specialties, 25% in each, whatever the specialty is involved, and this, Ms. Ratton said that the appropriate standard of care is unclear. The appropriate standard of care is the specialty that's being exercised at the time. There's no dispute that the specialty being exercised at the time is facial reconstructive surgery. Her own expert acknowledged that. So if that's what's being specialized in at the time, then the expert has to spend the majority of his or her time in that specialty. And I guess.
So the answer would be no, there's no expert
Well, if there's not a
qualified.
single expert in the country, that's a tough case, obviously. I mean, but I think it's worth noting that in this case, all that was required is that they have a plastic surgeon, someone facial reconstructive plastic surgery more than 50% of their time. It's not exactly an onerous burden. I think it's worth pointing out. And there's a logical basis for it, as I tried to explain, given the nature of this case. And I think that's the danger, I would respectfully submit, of a judge opining based on I'm not sure what, that the standard of care for performing a single rhinoplasty is the same regardless of whether it's for cosmetic or medical reasons. If you opine that, and the facts of the case are really quite different, they involve the decision whether to do a 12 rhinoplasty. Now, that's exactly why I think courts should refrain from second-guessing the legislature. I mean, the legislature said what they said. There's no ambiguity about the word majority. A majority means more than half. And
So counsel, today, are you here as an appellate attorney today or a med mal defense attorney today?
Well, I think probably both. I think that I get your point, Justice
So,
Welch.
yeah, like the majority of your time today, how's it been spent?
I get your point.
Yeah, it's hard, I know.
I take your point, Your Honor, but again, I mean, these are criticisms of the legislation, and I think it's important to point this out. In fact, I would also add, the plaintiff's counsel in the last case lodged 3 different criticisms of Woodard. None of them involve this issue, that there's somehow something wrong with the most relevant specialty test. Because again, that's the only way to interpret the language. I've never seen another way to interpret the language. There's a couple of dissenting opinions, one from Judge O'Connell, one from, I think, Judge Krause, that said, well, majority actually means plurality. No, it doesn't. It just doesn't. Majority means more than 50%.
Can you address your opposing counsel's point about the statute, about B1 and B2, and the significance of them saying either or both?
Right. Well, yeah, I mean,
do you think she's like correct in that?
I think her argument is incorrect.
Okay,
The
tell me
point,
why.
well, the statute says you can have your specialty in one or the other. Either you practice in the area or you teach. That's it. The one is practicing in the
Either or both.
Yeah.
So if you do both, you practice in one and you teach in the other.
I'm not sure where the either or both is that we're talking
At
about.
sub B, 2169,
To either or both of the
1
following.
B, I, 2I, I guess.
Yeah, no, I get it. Well, I think the intent of that statute, or that part of the statute is to say you can specialize either in teaching or practicing, and there probably, that also accounted for the situation where a doctor actually teaches and specializes. He's practicing in the area of, say, facial and reconstructive surgery, and he teaches. He teaches and practices.
So you
Something do that.
could make up the 50 by saying, well, I do 30% practice and 30% teaching, neither of which would give me 50, but if you add them together, then we're at 60?
I mean, I don't think so. That's a hard question. I think because in that case, if, say, he spent 70% of his time practicing and teaching in a completely heart surgery, then I think it's not, you can't really say in that situation that he's spending more than 50% of his time in reconstructive surgery under your hypothetical.
Let's take this discussion and try to apply it to this case. There seemed to be some aspect of Dr. Armstrong's testimony in which he had difficulty splitting his professional time neatly between the 2 specialties, or between the reason why he performed this particular procedure. So given this, why was the trial court outside the range of principled outcomes in rendering its ruling, precluding this expert?
Well, because I think the trial court quite clearly misunderstood his testimony. And maybe I'm taking issue with your premise, Judge Sarah, but he said 3 different times that he spent 90% of his time doing ENT work. He didn't misunderstand. He understood the difference between ENT specialty and facial and plastic surgery. And by the way, if I can just mention this, this is not a case where you have a specialty and a subspecialty. I know the court knows that, but I think it's worth pointing that out. There's no dispute that these are 2 completely different freestanding specialties. Dr. Armstrong knew it, and his testimony, I would submit, is unequivocal that he spent 90% of his time doing ENT. I think that, and the Court of Appeals, I think, understood that. I would also say that if this court disagrees with the Court of Appeals on that, that's not exactly the most compelling basis to grant leave, based on a disagreement that the Court of Appeals found an abuse of discretion. I think the judge did abuse his discretion because he did not adhere to the one most relevant specialty standard, and he misinterpreted Dr. Armstrong's testimony. That's my understanding of it. But let me just add this, too. I think it's important to keep in mind that these were legislative amendments. I mean, if the legislature had passed the post-amended version in 1993 as an initial freestanding piece of legislation, it might make a little bit more sense for a court to look at that and say, you know what, this majority of professional time devoted to the same specialty seems a little harsh. It seems like the legislation's intent might have been satisfied if it was a substantial portion of time in the same specialty or a related specialty. And you can see where I'm going with this. That is what they had said. They had said what Ms. Ratton wished they still said. So the legislature obviously knew the difference between a substantial portion of your professional time on one hand and a majority. And they knew the difference between saying the same specialty or a related relevant specialty or the same specialty. There can be no question what the legislature intended. They intended the test that was adopted in Woodard. And there hasn't been any explanation of how there can be any different test on this aspect of Woodard. And so I would urge the court, if you do revisit Woodard, there certainly is no basis to revisit the one most relevant specialty test, because that is the only way to interpret the statutory language. And I would just add that when you stop and consider that pretty much the entire premise of their argument is that Woodard and the one most relevant specialty test and 2169(1)B is logically inapplicable to this case. Number one, that's a problem because the legislature said otherwise. They said it does apply to this case. But number two, it's not logically inapplicable for the reasons I explained in response, or I tried to explain in response to Judge Welch's question. And therefore, the takeaway being, this is hardly a good candidate for revisiting Woodard. Or even if the court was inclined to create a logically inapplicable exception to the statute, this is not a very good case. A better case would be a case where you do have one rhinoplasty that was defectively performed. This case involves a lot more than that, as I tried to explain. If the court has any questions, I'll try to answer them, but I see that my time is up.
Well timed.
Thank you. You have 1 minute and 47 seconds.
Defense counsel, has harped on my use of the phrasing logically inapplicable in my briefing, and perhaps I should have been more precise. I am not saying, to be clear, that MCL 62169 is inapplicable in certain malpractice cases if the test is no longer workable. Clearly, the statute is always applicable in medical malpractice cases. It says that. What I'm saying is that in medical malpractice cases where you must apply the statute, Woodard requires you to apply a test that by the facts of that very case makes no sense. That is what is logically inapplicable. The test is logically inapplicable. The statute itself, its plain language, is not illogical. I checked the date that the statute went into effect, and it was in October of 1993, so I was like 4 months old. So I can't speak about the wild west of malpractice pre the 1993 statute, but I understand there were very real and compelling reasons for the change in the statute, that there was a very real concern about experts who were just paid, didn't really know what they were talking about, did not practice the medicine. I understand there's a real reason behind the statute. I understand the legislature spent a lot of time choosing the words they put into the statute. And I don't know how defense.
Just because you're focusing on the statute, walk us how you win under the statute. Or start with that, or either the statute as written or a Woodard alternative. And I
So-
feel like you've kind of touched on that, so focus on the statute.
Right, so under the statute, you match the boards, that's subsection A. What is the defendant doctor board certified in? If he is not board certified, as some may not be, the statute covers that as well, because it discusses a specialty. So if there is no hard and fast board certification, or if a doctor is practicing outside of his board certification, what is the specialty? What is he holding himself out as? That gets you over A. Then you turn to B, the active clinical practice requirement and the one most relevant specialty test. And truthfully, I don't necessarily have an issue with a relevant specialty test. I have an issue with one most relevant specialty test. Yes, it should be the relevant specialty. It should be a relevant specialty. There are sometimes more than one relevant specialty. To constrain trial courts and practitioners to one singular specialty when multiple specialties can perform the same procedure is not workable, and it is not consistent with the language of the statute. In the same way that a majority means greater than 50% test is unworkable and is not in the statute. And that's not even from this court. That's from the Court of Appeals in Kiefer. The language of the statute discusses a majority, not the majority, a majority. And in the same sentence uses language as either or both, which leads me to believe a majority can include two things, which is consistent with another dictionary definition of what majority means, which is the greater part of a whole. It does not always have to mean greater than 50%. And all of these judicially created tests that came after Woodard are the problem. The language of the statute is not the problem. You look at the board certifications, you look at the relevant specialty, understanding it may be more than one, and if the doctor, the proposed expert, satisfies those two criteria, he's qualified to testify under the statute. You can still attack his credibility under other parts of this statute, under the rules of evidence. You can just try to drag him through the mud in front of the jury, whichever way you want, but he is still qualified to speak about the appropriate standard of care. So I think if you just focus on that language, and I know defense counsel says this isn't a great case to re-examine Woodard, but I argue this is the best case to do that, because these men are mirror images of one another. They are the same board certifications. Where the roads diverge is when a trial court is forced to select one most relevant specialty from two relevant specialties, both of which perform the procedure, both of which these men practice. So even if you agree, nothing about my case should be reversed. Even if that's the ultimate conclusion of this court should take this opportunity to re-examine Woodard, at the very least, to just agree on what the majority opinion is and dispel that confusion that came out of Woodard. But the bench and bar, as evidenced by the arguments today, very clearly need this guidance. And I would encourage the court to take this opportunity at this time to lend that to the bench and bar. Thank you.
Thank you. Thank you both. The case will be submitted.